copyright protection. There is always confusion about copyright, so we're going to discuss and get that all cleared up here. So a copyright exists as soon as an original work of authorship is fixed in a tangible medium of expression. So you don't need to register. We'll get into this in a minute, but it exists as soon as you write something down. So that's what it means by a tangible medium of expression. So you've written something down, you've saved it to your hard drive. It is immediately protected by copyright at that moment. Now, what does an original work mean? The courts have said it just means some level of creativity, a creative spark. It does not have to mean that it's a novel concept that nobody has ever thought of this before. And so it just needs to be something original. So, and it applies to both published and unpublished works. And published in this case just means it was made available to the public. So for instance, if you post it on your website, that means it's published. And again, let me emphasize that it exists from the time the work is created. Now here are some things. Let's discuss what cannot be copyrighted, because not everything can be. You'll see that titles, names, short phrases, these kinds of things cannot be copyrighted. So sometimes you come up with something clever, just kind of a short phrase. No, that cannot be copyrighted. That, ideas cannot be copyrighted. That's discussed a lot in the writing community. People say, oh, stole my idea. Like, well, there's lots of ideas out there. It's the way that you write them down and create them. That's what's going to be copyrightable. And things that are entirely common knowledge, for instance, calendars, height, weight charts, and information from federal public government documents is not copyrighted either. Now, of course, there are some other methods that some of these things can be protected under the law, like trademark and patent might be available for certain things, like for the short phrases, the title, those kind of things might be able to be trademarked, and we'll talk about trademark a little bit later and how that applies to writing. And then, of course, lists of ingredients, like patents may be available for that kind of thing. Like you always hear the famous recipe for Coca-Cola that that's patented. So in some cases, recipes can be patented, and in some cases, if they have many creative elements to them, recipes could be perhaps copyrighted, but not just the list of ingredients. Now you'll see that facts can't be copyrighted. However, do keep in mind that if you come up with a creative way to organize facts in a selection and a coordination arrangement in an original way, for instance, I'm thinking of travel guides, restaurant guides. These are all facts. You can't copyright the name of the restaurant or a hotel, but if you've organized it in a creative way, and maybe by geographical location or food styles, and you've added original material to it, like descriptions of foods and hotels and those kind of things. So then, of course, then your guide would be copyrightable. So what about that copyright symbol? A lot of people worry about this, but it is no longer necessary to put on your works as of 1989. So it changed quite a while ago, but you used to have to put that on for the copyright protection, but no longer. But I still recommend you do use the copyright symbol. The use of the mark is important. It identifies you as the owner, the year of first publication, and it just puts others on notice that you wrote the work and it is copyrighted. As I say, it's copyrighted from the minute it comes into creation, but there's a lot of people out there who don't know that, and if they don't see the copyright symbol, then maybe they think it's not copyrighted.